Amended petition for dissolution of marriage and request to be allowed to relocate with the minor children. Relocation with minor children. The wife shall be residing at address. The mailing address of the intended new residence is the same as the physical address. C. The home telephone number of the intended new residence is phone number. D. The date of the intended move or proposed relocation is as soon as possible because the wife has been offered a job in Boca Raton, Florida, beginning May 1st, 2013. E. The specific reason for the proposed relocation is that the wife has been offered a job in Boca Raton, Florida, paying her substantially more in salary and year-end bonus than her current job as a clinical professor. The job offer for the position of an attorney with Grossman Roth, PA, is reduced to writing and is attached here too. The wife also desires to relocate to South Florida in order to provide a better quality of life for the children by increasing their access to close family and providing more stability and consistency. First, neither the wife nor the husband, who is a Canadian citizen, has any family in Tallahassee. By contrast, the wife's parents reside in Coral Springs and the wife's brother resides 20 minutes away. The children are very close to the wife's parents, as they have visited every 3 to 4 weeks since the birth of the children. Furthermore, the husband travels a great deal, approximately 45 to 55 days away from the family each year. Second, the husband and wife both work for the Florida State University School of Law. The husband is a tenured professor while the wife's position is on a non-tenure track and a more tenuous one. The husband has indicated to the wife that her employment at FSU Law School is solely dependent upon his discretion. The husband has also created a hostile work environment for the wife at FSU School of Law by telling the administration and their joint colleagues that the wife has stolen from him and that she has mental health issues, isolating the wife in Tallahassee's small legal community and further limiting the wife's career prospects in the area. The husband has been constantly dropping into wife's office unannounced, uninvited, and undesired. The husband continued to do so until asked to stop by legal counsel. Finally, since arriving in Tallahassee in 2005, the husband has indicated his intention to seek employment at another law school outside of Tallahassee. He has consistently, through the years, sent out resumes and has at one point even accepted a position at another school, which then fell through. With no roots to bind either party to Tallahassee, other than the husband's position as a law professor, the wife believes that the party's time in Tallahassee is tenuous. These facts demonstrate an unstable environment that does not serve the best interests of the children post-dissolution of marriage. The wife seeks more consistency and stable employment to improve the quality of life for herself and her children. F. The wife proposes that the parties' timeshare be on a 60-40 basis, as the husband has access to his great-uncle's 2-bedroom apartment in Hallandale, Florida, and his aunt and uncle's 3-bedroom apartment in Pembroke Pines, Florida. The husband has a very flexible schedule so that he can come and see the children as often as he would like for extended periods of time. The husband only has teaching responsibilities 2 days per week during the fall and spring semesters and does not teach during the summer semester. The wife proposes that during the school year, the husband come to South Florida every other Saturday through Tuesday, and in the off week come for at least 2 days to see the children. The wife also suggests alternating the major holidays and extended time for the husband with the children in the summer. The wife proposes that for these extended times, the children travel to Tallahassee or wherever the husband is living. The cost of transportation should be shared, if it is not otherwise paid for, by the husband's employment. G. The court should consider the following in making its determination. 1. The nature, quality, extent, and involvement and duration of the children's relationship with the parent or other person proposing to relocate with the child and with the non-relocating parent, other persons, siblings, half-siblings, and other significant persons in the child's life. The wife has extended family and friends in the South Florida area, and the husband has no family in the Tallahassee area. The minor children have no other siblings. The children are close to both parents. 2. The age and developmental stage of the child, the needs of the child, and the likely impact the relocation will have on the child's physical, educational, and emotional development, taking into consideration any special needs of the child. The relocation will not materially impact the children because they are not yet school age. They will be allowed to emotionally develop well and will have more support from extended family relationships. 3. The feasibility of preserving the relationship between the non-relocating parent or other person and the child through substitute arrangements that take into consideration the logistics of contact, access, and time sharing, as well as the financial circumstances of the parties, whether those factors are sufficient to foster a continuing, meaningful relationship between the child and the non-relocating parent or other person, and the likelihood of compliance with the substitute arrangements by the relocating parent or other person once he or she is out of the jurisdiction of the court. The wife will comply with all substitute arrangements, and the parenting time for the husband should be as extensive as his employment and health will allow. The husband suffers from Crohn's disease, persistent episodes of vertigo, and back problems that resulted in surgery in December 2012. When any combination of these issues arise, he is unable to care for the children on his own. 4. The child's preference, taking into consideration the age and maturity of the child. The children are too young to voice any preference. 5. Whether the relocation will enhance the general quality of life for both the parent or other person seeking the relocation and the child, including but not limited to financial or emotional benefits or educational opportunities. The quality of life for both the wife and the children will improve greatly because the wife will have a better, more consistent job, the help of extended family, and the children will have increased access to extended family as well. 6. The reasons each parent or other person is seeking or opposing the relocation. The wife is seeking to relocate for a better, more stable job and to have the children grow up in a stable and consistent environment and not repeatedly relocate across the country as the husband moves for ever better positions. 7. The current employment and economic circumstances of each parent or other person and whether the proposed relocation is necessary to improve the economic circumstances of the parent or other person seeking relocation of the child. The wife's employment is going to be considerably better with this move. The husband has no intention of staying in Tallahassee and has consistently expressed his intent to move to a much larger city and more prestigious school. The husband is considered Miami, Houston, New York, Washington, D.C., and St. Louis among his choices. 8. That the relocation is sought in good faith and the extent to which the objecting party 8. That the relocation is sought in good faith and the extent to which the objecting parent has fulfilled his or her financial obligations to the parent or other person seeking relocation, including child support, spousal support, and marital property and marital debt obligations. The wife is seeking this relocation in good faith. 9. The career and other opportunities available to the objecting parent or other person if the relocation occurs. The career opportunities for the husband are the same regardless of the wife's relocation and will create a situation where the transportation is even better for the husband when he moves to a larger metropolitan area. 10. A history of substance abuse or domestic violence as defined in Section 741.28 or which meets the criteria of Section 39806 sub 1 sub D by either parent, including a consideration of the severity of such conduct and the failure or success of any attempts at rehabilitation. This is not applicable. 14. Wife has retained Kristen Adamson to represent her in this cause and has agreed to pay her a reasonable fee for her services plus suit, money, and costs. Based on the relative financial circumstances of the parties, husband should be required to pay or contribute to wife's attorney's fees, suit money, and costs, both temporary and final. A response to the petition objecting to relocation must be made in writing, filed with the court, and served on the parent or other person seeking to relocate within 20 days after service of this petition to relocate. If you fail to timely object to the relocation will be allowed unless it is not in the best interest of the child, without further notice and without a hearing. Wherefore, the petitioner wife, Wendi Adelson, respectfully requests that the court grant her requests contained in her petition for dissolution of marriage filed on September 10th, 2012, this amended petition for dissolution of marriage, as well as this petition to relocate to Miami, Florida, with the minor children. Signed, Wendi Adelson. Husband's objection to wife's request to relocate with minor children, with prayer for relief. Objection to wife's request to relocate with minor children. A. Once examined in context, the sole stated reason the wife seeks to relocate with the party's minor children is so she can be closer to her parents. Footnote 1. In a January 2013 electronic communication to husband, wife claimed that she thought relocation was, quote, in the best interest of our kids to be closer to family, more access to a Jewish community, and a happier mom, close quote. She doesn't mention the economic rationale at all, which lies at the heart of her filed petition. And her written petition doesn't mention the Jewish community at all because the facts are the wife has done nothing to facilitate the children's connection to the Jewish community since the separation. She not only introduced them to a non kosher diet since the separation, but on her weekends, she refuses to allow husband to continue their pre separation practice of bringing the children every week to synagogue for services and Sunday school, notwithstanding that husband has offered wife time sharing offsets in exchange for allowing that to happen. Accordingly, the only reasons for the relocation are, quote, happier mom and more access to wife's parents. As the court stated in Coyle v. Coyle and in numerous other cases, relocation cannot be based simply upon a finding that the relocation would serve the best interests of the relocating parent. Fredman versus Fredman, affirming the trial court's denial of relocation because relocation was found only in the mother's best interest, but not the minor child's. Berebi versus Clark, reversing an order granting a relocation request because any evidence regarding the benefits of relocation related to the mother and her new husband. And there was no evidence that relocation would be good for the minor child. B. The husband currently lives in the party's marital home, which the wife, with children in tow, stealthily and abruptly abandoned in September 2012. Footnote 2. On September 10th, 2012, after 2 days of not answering husband's calls or texts, wife urgently called husband while he was on a short business trip in New York City and told him for the first time and over the phone that she wanted a divorce, notwithstanding the absence of any infidelity, abuse, or neglect by either party. He begged for her not to do anything until he returned and that he would be on the next flight home. Arriving at home that night, he was shocked. Wife was gone, the boys were gone, the house was half plundered, the Schwab accounts had been raided, and divorce papers were left on the bed. Most importantly, there was no indication of where the wife and children were. Worse, for the first 15 days of the separation, wife refused to give husband any address or phone number for where she lived with the children. Thus, when the children were not with the husband or at the preschool, the husband had no idea where his children were. On September 25th, 2012, wife finally answered husband's and his counsel's plea for a proper address, but she gave him a false address that wasn't corrected until 4 weeks later. The wife currently resides approximately 10 minutes from the marital home, and both parties live approximately 15 minutes from their children's preschool. The preschool is also 10 minutes from the FSU College of Law, where both the husband and wife are employed. The parties have two minor sons, Benjamin and Katie Magbanua, born July 29, 2009, age 3, and Lincoln Jonah Markel, born October 3rd, 2010, age 2 years. D. Prior to the wife's abandonment of the marriage and home, the husband was actively involved as a father. The husband and wife both worked at the FSU College of Law in jobs that provide significant flexibility and opportunity to care for the children. After the birth of the party's first son, the husband had a light teaching load in the fall of 2009. Following the birth of their second son, he was permitted to take a semester of parental leave in the fall of 2011. Throughout the children's lives, the husband has been immersed in parenting, routinely taking them to doctor's appointments, cooking for them, bathing them, and visiting them at their preschool for circle time and daytime meals. He is, in short, an integral and positive part of their daily lives. E. Since the parties' separation, the parties have had equal 50-50 time sharing with the minor children. Since October of 2012, they have had an alternating 2-2-3 time sharing schedule with adjustments and offsets made for travel, work, and other preferences regarding holidays. This rotating time sharing schedule effectively provides each parent with 7 nights out of every 14 with the children. Additionally, the parties have agreed on a communication schedule for time apart and a condition that allows both parents to regularly spend time with the children at their preschool during the week to facilitate ongoing and continuing contact with them. Therefore, since the parties' separation, the husband has effectively had access to and visits with the children 12 out of 14 days. Conversely, and importantly, because the husband is committed to including the wife in the life of the children as much as possible, the husband has offered the wife greater access to the children than she has given him by offering Skype calls or in person visits on any day he has the children so the parties can co parent. Unfortunately, to date, the wife largely ignores the children on days and evenings that she does not have responsibility for them. F. The wife submits as her principal reason for to allow relocation a job offer with the personal injury law firm of Grossman and Roth for $115,000 per year. The wife has never worked in a private law firm since her graduation from law school 7 years ago and was recently promoted to and accepted the position of clinical professor at the FSU College of Law. The wife earns at least $100,000 a year in this new position, not including generous benefits and perks. Once cost of living adjustments are made, employment at Grossman and Groth is equivalent to her current pay and maybe even less when benefits are figured in. Furthermore, in the new position, she would have to commute more than an hour a day and work substantially longer hours than she does at the FSU College of Law. Moreover, unlike her proposed job, her current position at FSU offers the equivalent of tenure, such that she now has long-term job security. For example, other faculty members at the FSU College of Law with similar positions, Professors Anino and Stone, have been teaching there for almost 20 years each. If the wife were already employed at a law firm such as Grossman and Roth, and the FSU College of Law were to offer her a position she now if the wife were already employed at a law firm such as Grossman and Roth, and the FSU College of Law were to offer her the position she now has, it would be obvious that the position she now has would, in fact, redound to the benefit of the children. In the wife's current position, she teaches students roughly 34 weeks a year, and her teaching obligations require her to be at school for a designated period of 6 hours a week, providing tremendous day-to-day flexibility, much like the husband's job does. The very fact that the wife is seeking to change her current employment and relocate reveals an inability to prioritize the children's well-being, since her proposed employment would not only drastically impede and reduce the husband's access to and involvement with the children, but would also substantially reduce her own ability to spend time with the children. At the same time, she would dramatically reduce her own job stability, flexibility, and quality of life. Her proposed new job provides no gain of any significance to the children's best interests. More basically, the economic rationale for the wife's petition is made in bad faith. The wife claims that the job in South Florida at the Grossman Roth firm will pay her more, and that's why she wants to relocate. Nowhere in her petition does she even allege that she, A, is inadequately compensated in Tallahassee to maintain a good quality of life for the children, or more importantly, B, that she has made any effort to find a higher paying job in Tallahassee. Her utter failure to show any efforts to find a higher paying job in Tallahassee reveals that she is not at all interested in relocating for financial purposes, but rather that she simply wants to leave Tallahassee after living here since 2005 so she can move on with her life near her parents. G. The wife's second reason for moving is predicated on the allegation that the children will have more stability and consistency in South Florida. This argument is spacious. Children were born in Tallahassee and have lived their entire life in this town, where they have plentiful access to both parents, extended family members who come to visit, and over 50 families with whom they do playdates or celebrate milestones. The only inconsistency and instability in their life has been introduced by the wife's abandonment of the husband and her move to a new and unfamiliar home in the last few months. Notwithstanding that abrupt and furtive move, the children are, in the words of Dr. Phelps, the director of the preschool they attend, quote, flourishing. Sadly, the inconsistency and instability that the wife has wrought would be hopelessly exacerbated by relocation to South Florida, requiring 6 homes for the children to acculturate to in the space of a couple years. Footnote 3. 6 homes reflects A, 2 homes in Tallahassee currently experienced in the last few months, plus B, the proposed new home for the wife, which is her parents' home, plus C, a subsequent new home for the wife. The wife mentioned to the husband that she would only stay in her parents until she got settled in. Furthermore, if relocation were permitted, then the husband would also have to acquire D, short term, and E, permanent housing in South Florida. Indeed, if anyone has introduced instability to the children's lives, it is wife, first by unilaterally separating without any notice to husband and absconding with the children to a new and, for a while, unknown home. Footnote 4 refers back to footnote 2. And second, by continuing to by and second, by failing to continue or permit the continuation of the patterns of life that the children had grown accustomed to. Footnote 5. Further, the fact that the husband is Canadian is immaterial. He has a green card, and the only reason he is not a U.S. citizen yet is because the wife so abruptly left him and their home without any notice that it was before he had the chance to file his naturalization papers. Now, because of the wife's unforeseen and abrupt departure from the home, the husband must wait until June 2014 to naturalize, and he intends on doing that as soon as possible. The husband has lived in the U.S. all but 2 years since 1991, having spent 2 years abroad between his undergraduate and law school degrees at Harvard. The wife alleges that the husband wants to move from FSU, but that is false. Prior to the separation and prior to the promotions and job security gained by both the husband and the wife in 2012, the husband considered employment opportunities elsewhere only if they would benefit the couple as a family. Since the separation, both parents now have excellent and stable jobs. Accordingly, the husband, who was a chair, tenured, and beginning August 2013, full professor at the FSU College of Law, has no desire or intention of relocating to take another position. He wants to avoid any further disruption in the lives of his toddlers. Having raised the children here for their whole lives, and as a result of increasing stability and support from the FSU College of Law to both wife and husband over the last few years, the husband has no desire to leave the community in which he has spent the last 8 years. More urgently, with the separation thrust upon him by surprise and deception, one that he neither wanted nor expected, the husband has no desire to further disrupt the lives of his beloved children, with whom he is actively engaged in parenting. H. The wife's third reason for moving is to acquire more access to her extended family in South Florida. Ultimately, this is the sole basis of the petition, but it is legally inadequate. By the wife's own admission, even though her parents reside in South Florida, they have visited in Tallahassee every 3 to 4 weeks since the birth of the children. Many times, the grandparents spent a week to a month or more with the children, either in Tallahassee or elsewhere. Since the party separation, the wife's mother and father have spent even more time in Tallahassee. There is no need for the children to be uprooted so that they can have a closer relationship with their maternal grandparents, especially when the relocation would only devastate the husband's parenting role, shrink the family assets, and substantially impede the wife's own parenting opportunities. The wife was offered and she accepted a raise and a full-time position at the FSU College of Law in December of 2012, some 3 months after the party separation. This, on its face, discredits the false allegation that the husband created a hostile work environment for the wife at the FSU College of Law or in Tallahassee. Importantly, the wife doesn't mention a single incident or example of this purported hostile environment. Moreover, the husband has used Facebook to congratulate and celebrate the wife on her recent achievements, which many members of the community congratulated her on. Footnote 6. Wife's petition also raises other equally spurious issues, such as husband's health and ability to care for the children. Over the nearly 4 years since the children's birth, husband has been able to care for the children, all but perhaps 5 weeks total because of health issues. Wife omits disclosing her own share of health issues, both physical and mental, or travel schedule that would also be relevant to the court's determination of the children's best interests. Husband was also dumbfounded by wife's claim about unwanted visits to her office. Wife never told husband not to come by prior to late October 2012, and indeed, husband specifically emailed wife on September 18th, 2012, quote, "I don't want to bother you at work if that's not a good place for us to chat, so just let me know. If you tell me how/when you'd like to communicate and how often, I will respect that. I hope we can just be gentle and cooperative with each other." Close quote. J. Under the wife's proposed relocation plan, the husband would have to commute 480 miles for time sharing with children and be unavailable on the other days and forced to be away from his children for daily breakfasts, special events, or emergencies. This would reduce the husband's parenting opportunities and remove the husband from their daily lives. From the husband's perspective, nothing could be worse. Contrary to the wife's petition, neither the two-bedroom retirement community condo of the husband's aunt and uncle, nor the one-bedroom apartment shared by the husband's 95-year-old uncle and his caregiver, both of which are 30 minutes to an hour away from the wife's proposed new home, have been offered or are feasible for husband and his children to live in. Accordingly, to maintain any time sharing, let alone equivalent time sharing, the husband would have to maintain 2 homes, 2 cars, and a weekly airplane fares and parking costs. To engage in the time sharing arrangement the wife proposes, the husband would be dependent on the College of Law to facilitate this. The College of Law might very well decide or need to assign the husband teaching or administrative assignments that preclude the kind of time sharing envisioned by the wife. In any event, seen in full, it would be parentally, professionally, financially, and socially destructive for the husband to have to commute roughly 480 miles for work on a weekly basis. K. Under the governing statute, the court must consider the following in making its determination. 1. The nature, quality, extent, and involvement and duration of the child's relationship. 1. The nature, quality, extent of involvement, and duration of the children's relationship with the parent or other persons proposing to relocate with the child, and with the non-relocating parent, other persons, siblings, half-siblings, and other significant persons in a child's life. As the wife acknowledges in her own pleading, the children are close with both the wife and the husband. This has been the case since the children were born. That said, while both parents are loving and devoted caregivers, the wife's erratic and untrustworthy behavior demonstrates an inability to make sound decisions on the children's behalf. In contrast, the husband can be trusted to consult and include the wife whenever feasible. Indeed, because the husband still wants the children to maintain a close relationship with the wife, the husband currently does not seek more or less than 50% of time sharing, assuming there is no relocation. If the wife decided to relocate without the children, he would find it regrettable, but would then seek to be the primary residential parent. However, the husband strongly opposes any relocation with the children, as this would be devastating to him from a parenting perspective, would be severely detrimental to the children, and would be severely detrimental to the husband from a professional, financial, and social perspective. As stated earlier, he is utterly immersed in the lives of the children and has continued to be since the parties' separation. Indeed, the husband makes substantial efforts to spend as much time as possible with the children as frequently as possible and works to create conditions under which the wife would be able to see or spend more time with the children. The children were born and raised in Tallahassee, attend preschool in Tallahassee, and according to the director of their preschool, are, quote, flourishing. In short, the children's friends, teachers, and doctors are in Tallahassee, as is their synagogue, which they attend regularly. What's more, the children are still visited by each set of grandparents and other extended family regularly. There is no need or benefit to ripping up the fabric of their lives. 2. The age and developmental stage of the child, the needs of the child, and the likely impact the relocation will have on the child's physical, educational, and emotional development, taking into consideration any special needs of the child. It is the policy of the Florida legislature that minor children, especially very young minor children, be in frequent, continuing, and meaningful contact with both parents to ensure strong relationships. See Florida Statute 61.13, Collins v. Collins. Generally, the younger the child, the greater the need for frequent contact with both parents. Footnote 7. Courts acknowledge the special importance of maintaining such contact with both parents, in part because of the copious research that supports the significance of fathers in particular, a view advanced by leading child psychologists. See, for example, Michael E. Lamb, critical analysis of research on parenting plans and children's well-being in Parenting Plan Evaluations, Applied Research for the Family Court. The clear indication of the research is that active paternal involvement, not simply the number or length of meetings between fathers and children, predicts child adjustment. This suggests that post-divorce arrangement should specifically seek to maximize positive and meaningful paternal involvement. See also Michael E. Lamb, The Role of the Father in Child Development, 2010. Dr. Lamb is a psychology professor in the social sciences at the University of Cambridge, who has appeared as an expert witness in the United States in various high-profile cases and courts. Because of the wife's proposed new demanding position and the impact relocation would have on the husband, the wife's proposed relocation would dramatically injure both parents' ability to stay closely and actively involved in the lives of their children. Obviously, this is a vital consideration when considering the children's emotional development. Under the parties' current rotating time-sharing arrangement, the husband cares for the children on half the nights and virtually all of the weekends that he can, and visits them at Creative Preschool, where he spends time with the children on a daily basis. In short, he sees them 12 out of 14 days and has endeavored to reach agreement with the wife to facilitate more access and overnights for both parents. Finally, social science research reveals that relocation is very difficult for children since it deprives them of the social capital or, quote, psychological resources that would otherwise be invested in and available to the children from the non-relocating parent. See generally William G. Austin, Relocation Research and Child Custody Disputes. 543 in Parenting Plan Evaluations, Applied Research for the Family Court. Dr. Austin summarizes the findings of various studies of the pernicious efforts of relocation on children. Bullet: the majority of college students whose parents had divorced wished they could have spent more time with their father or even equal time. Quote, the importance and unique contributions of fathers have also been empirically established. Bullet: relocation and economic changes associated with divorce are the two most potent predictors of the children's adjustment, and they explain 2/3 of the variations between intact families and divorced ones along the dimensions associated with academic achievement, school dropout, child psychological well-being, and teenage pregnancy. Quote, multiple moves create more risk, but only one move produces the relocation effect. In short, relocation, quote, is a general risk factor for children of divorce. Quote, there is a base rate of harm associated with relocation that can be established for children of divorce. Bullet: theory and research suggests that very young children are at higher risk for adjustment problems due to relocation. Bullet: a past pattern of restrictive or inhibitory gatekeeping by the moving parent makes it more likely that the other parent will have difficulty sustaining a quality relationship with the child. Seen in context of this family and the wife's past misuse of access to the children as pawns in her relationship with the husband, there is little reason to be especially hopeful that the children won't be subjected to these harms. 3. The feasibility of preserving the relationship between the non-relocating parent or other person and the child through substitute arrangements that take into consideration the logistics of contact, access, and time sharing, as well as the financial circumstances of the parties, whether those factors are sufficient to foster a continuing, meaningful relationship between the child and the non-relocating parent or other person, and the likelihood of compliance with the substitute arrangements by the relocating parent or other person once he or she is out of the jurisdiction of the court. Since the parties' separation, the husband has worked exceedingly hard to communicate with the wife regarding their time sharing schedule. And though the parties have exercised equal time sharing since their separation, it has been difficult to maintain this arrangement with the wife. The wife's penchant for deception or lack of transparency has manifested itself in various ways that are relevant to determining that she cannot be trusted to keep her commitments with regard to parental time sharing. For example, despite the parties' agreement to same, the wife has, on various occasions, failed to allow the children to Skype with the husband, and she denied the husband his agreed upon time with the children for Halloween of 2012. The wife has consistently failed to honor other time sharing agreed upon in the parties' emails. She has backed out of agreed upon counseling, even when such counseling was intended only to facilitate communication between the parties. Unfortunately, the broken promises, communication withdrawal, and deceitful behavior indicate that the wife really cannot be trusted to consider the children's best interests or the husband's reasonable parenting interests, in contrast to hers, in any manner that approximates fairness. 4. The child's preference, taking into consideration the age and maturity of the child. The children are too young to voice any preference. 5. Whether the relocation will enhance the general quality of life for both the parent or other person seeking the relocation and the child, including but not limited to financial or emotional benefits or educational opportunities. Despite the wife's allegations to the contrary, the quality of life for the parties and the children will not improve and, in fact, will be severely deteriorated if this court allows the wife to relocate with the parties' minor children to South Florida. Specifically, the wife will commute more, work longer hours, will be away from the children for more hours per day, and will receive less compensation when taking into account the cost of living, and less job stability and flexibility. Furthermore, relocation would force the husband to expend exorbitant sums to travel to the children for his time sharing. 6. The reasons each parent or the other person is seeking or opposing the relocation. The wife is seeking to relocate for a better paying job as a law firm associate. However, as explained above, the economic rationale for moving is implausible and was not even mentioned to the husband when the wife broached this in January 2013. The wife also complains of instability in the children's lives posed by the husband's ambitions when, in fact, the husband is not seeking any other employment at any other institution. The wife wants to move only to facilitate her own preferences to be with her parents in South Florida. The only source of instability in the children's lives is the wife. The husband opposes relocation because it would devastate his parenting role and pose unreasonable financial, professional, and social burdens, as explained above. 7. The current employment and economic circumstances of each parent or other person, and whether the proposed relocation is necessary to improve the economic circumstances of the parent or the other person seeking relocation of the child. Petitions to relocate are sometimes granted over opposing motions when there is economic necessity for a family. Florida Statute, Section 61.13001, Sub 7, Sub G. Orta versus Suarez. Wife could not be certified as a dentist in Florida, and husband's misrepresentations as to income left her and the child with only $1,100 a month. The key issue here, there is literally no economic necessity for the wife to relocate to South Florida. Both parties are currently employed in high paying, stable, and flexible jobs that are conducive to the well being of the children. Indeed, the wife recently acknowledged in an email that she is grateful that her current position affords her the flexibility to spend time with the children. As explained above, the wife's employment is not going to be considerably better if she relocates. Her job offer from the law firm in South Florida would require the wife to work substantially more hours for virtually the same amount of income as she currently receives without any job security. Moreover, she does not even allege that she had trouble making ends meet or that she made efforts to find a higher paying job in Tallahassee. The husband has recently been promoted to full professor and has no intention of leaving Tallahassee. Prior to the birth of the party's children, he did interview with other schools, but that was done with an eye toward improving the fortunes and good stability of the couple. Once FSU made commitments to both the husband and the wife, and once the children were enmeshed in a loving community, there has been no need to look elsewhere, and the husband is very happy raising his children here and doing his teaching and research here. Moreover, any travel that the husband does is completely optional at this point and occurs when the wife has the children pursuant to their 50-50 time sharing arrangement. The wife's petition also omits that she travels extensively and was away herself from the children for almost 5 weeks during the spring of 2012 alone. 8. That the relocation is sought in good faith and the extent to which the objecting parent has fulfilled his or her financial obligations to the parent or other person seeking, including including child support, spousal support, and marital property and marital debt obligations. Because there are numerous false statements in the petition to relocate, and because the wife's behavior, both generally and specifically, surrounding the filing of the petition to relocate reveals deception, lack of integrity, and other instances of bad faith, this court, which acts in equity, should look at the wife as having unclean hands. By contrast, the husband has diligently sought to include the wife in all decision making and has also fulfilled his financial obligations. 9. The career and other opportunities available to the objecting parent or other person if the relocation occurs. The husband is a tenured full professor with a chair on the best law faculty in Florida. No other school in Florida has offered him or could offer him the same package of compensation, benefits, and research opportunities as FSU. Moreover, at the wife's request prior to the birth of the children, the husband previously sought employment with the University of Miami School of Law, but they had no positions available for him. In short, the husband should be able to maintain his current employment, which enables him to remain a devoted and doting father to his children. 3. Prayer for relief. This court should dismiss the petition to relocate for failure to establish the predicate for a cognizable claim to relocate. Indeed, the wife, who unilaterally helped herself to $400,000 of assets she only barely contributed to, should be forced to bear the full legal costs of this frivolous petition, which emerged during a period in which the wife lulled the husband into believing that they could resolve most of their issues amicably and with little outside intervention. Finally, if the wife is willing to stay in Tallahassee, then this court should award time sharing on a rotating basis of a 50-50 principle, but should award decision-making authority over education, medical, and religious matters solely to the husband, and decision-making on all other matters to the parties jointly. If the wife moves to South Florida to take this proposed job, then the children should remain in Tallahassee with husband on a full-time basis, and the wife can stay in or near the marital home or visit or watch the children at least every other weekend, with more time based on mutual consent and any travel costs being borne by wife. Additionally, the husband will allow the wife to have the children in South Florida under such a plan each year: 1, for a week around mid-March; 2, 1 week around July 4th; 3, 1 week around Thanksgiving; and 4, 2 weeks around Christmas. The expenses of transporting the children would be shared like other child-rearing expenses. Signed, Daniel Markel. Husband's memorandum of law in support of his answer to wife's amended petition for dissolution of marriage and objection to request to be allowed to relocate with the minor children. and husband's motion to dismiss wife's petition to relocate. Comes now the respondent husband, Daniel Markel, and files this one memorandum of law in support of his answer to wife's amended petition for dissolution of marriage, an objection to request to relocate with minor children, and two, husband's motion to dismiss wife's petition to relocate, and in support thereof states: 1. Brief background. On September 10th, 2012, after 6.5 years of marriage without any abuse or infidelity, wife abandoned husband and the marital home, taking with her the children, hundreds of thousands of dollars, whichever furniture and belongings she wanted for herself and for the children, and numerous non-marital items belonging to husband. Her departure from the home occurred without any notice to the husband, who was on a short business trip for a few days and returned to find divorce papers left on the bed. Most importantly, the children were gone. Since separation, the parents have been exercising equal time sharing with the children. However, for the first 6 weeks, wife would not share any correct information regarding her and the children's whereabouts. This was very difficult for a father devoted to his two sons, who at the time were 3 and 1, respectively. Despite the fact that both parents are well paid, recently promoted, and stably employed as professors at the Florida State University College of Law, in January of 2013, the wife filed an emergency amended petition for dissolution of marriage and request to be allowed to relocate with the minor children with this court. The wife sought the court's permission to relocate with the children and take them with her to her parents' home in Coral Springs, Florida, about 460 miles away from Tallahassee, where the children have lived their whole lives. Husband has already filed his answer to that amended petition and now, in support of his answer, offers this memorandum of law. He further moves the court to dismiss the wife's amended petition with courts awarded to husband. 2. Legal standards. A. Petitions to relocate generally. For a petition to relocate to succeed, the parent seeking the relocation bears the burden of proof to show that the current arrangement is somehow deficient from the perspective of the children, and that a preponderance of the evidence indicates that a relocation would better advance their interest than the status quo or other feasible alternatives that could be made to the status quo. See generally Florida Statute 61.13001 sub 8. After the Florida legislature overhauled its statutory framework in 2009, there is no presumption in favor of relocation. Instead, petitioner must establish that relocation and resulting modification of timesharing between parents would be in the children's best interest. Florida Statute 61.13001 sub 7. Among other things, courts must consider whether substitute visitation under a relocation would facilitate a substantial and meaningful amount of visitation similar to, if not identical in, quantity and quality of visitation as the existing schedule. See Schaefer v. Schaefer, where an injunction was granted to prevent mother from moving with children based on inter alia, which means, among other things, inadequate visitation opportunities. The Florida legislature has also recently passed SB 718, which places in the statute a presumption that the best interests of the minor children are served when parents engage in even time sharing. This legislation, passed overwhelmingly by a supermajority of Florida's representatives, weighs even more strongly against wife's desire to relocate, since her relocation proposal offers only 40% time sharing for husband and would, in fact, create conditions that would impede the husband's ability to engage in meaningful and even-handed time sharing. B. Nature of evidence. Evidence submitted in support of the petition to relocate must be competent and substantial. Vivian versus Shmabari, affirming denial of mother's petition to relocate based on the substantial and competent evidence introduced at the trial court. See also Mata v. Mata, reversing grant of a mother's emergency motion to relocate because the court limited its review to pleadings and argument of counsel. At no time did the court receive any evidence or testimony which would have provided a factual basis to support relocation. Indeed, there must be substantial and competent evidence to support the trial court's findings regarding all of the statutory factors delineated in the governing statute, Florida Statute 61.13001. See Rossman versus Profera, denying mother's petition to relocate with children and ordering modification of timesharing to favor father. Also, Eckert v. Eckert, reversing trial court's grant of relocation to mother because even with a 50-50 timesharing, relocation would, quote, place the father with a significant loss of contact because of the distance between them. C. Wife's preferences or interests are largely irrelevant bases for decision making. Importantly, as courts in this circuit and others have long held, relocation cannot be based simply upon a finding that relocation would serve the best interests of the relocating parent. See Coyle versus Coyle, reversing trial court's grant of primary residential mother's relocation petition because it erred by focusing, quote, on whether relocation would improve the quality of her life, not necessarily the life of the child. This was error. Also, Fredman versus Fredman, affirming the trial court's denial of relocation because the evidence indicated that relocation was in the mother's best interest, but not the minor child's, notwithstanding that father had comparatively fewer parenting responsibilities. Also, Berebi versus Clark, reversing an order granting a relocation request because, quote, any evidence regarding the benefits of relocation related to the mother and her new husband, and there was no evidence that relocation would be good for the minor child. Also, Kuntz v. Kuntz, the relocation statute imposes an intensely fact-specific framework on the relocation decision, where the trial court may base a decision on what is best for the child, even though a result may not be best for the parent seeking to relocate. D. All the relocation case law in Florida follows a very clear pattern that demonstrates the lack of merit in wife's petition. As the court in Valqui versus Rodriguez acknowledged, there are no Florida cases where an appellate court has allowed a relocation to occur when both parents are equally involved and there is no economic necessity to relocate. In Valqui, the court allowed the relocation because the child's new stepfather had been relocated pursuant to the United States Coast Guard's orders, and the mother had already and long been deemed the primary residential parent. Even under such different circumstances, the court exhibited great reluctance to allow the relocation to go forward in that case, acknowledging how difficult the decision was under such circumstances, but also recognizing the trial court's action was not an abuse of discretion. The court also acknowledged the force of Vivian versus Shmabari, a case where the court affirmed the denial of mother's petition to relocate with children when the mother's new husband was relocated for job purposes. And like Valqui, the mother had already been designated the primary residential parent. The short of it, accordingly, is that no Florida appellate court has allowed a relocation to go forward in circumstances like the one at issue, where there is no economic necessity and where both parents are fully and equally involved. Eckert v. Eckert, noting that the relocation statute requires a, quote, thorough analysis of the situation and the impact on both the children and both parents, close quote. Indeed, the appellate courts routinely and unhesitatingly reverse as abuse of discretion any relocations under facts similar to the ones like the litigants here. See Eckert v. Eckert, reversing the trial court's grant of relocation to mother and determining that it was an abuse of discretion to award relocation because even with a 50-50 time-sharing arrangement, relocation would, quote, place the father with a significant loss of contact because of the distance between the father and children. Sisemski versus Sisemski, reversing trial court's grant to mother of petition to relocate because inadequate evidence was presented to show that the relocation would create substantial economic improvement to children's well-being and that substitute visitation situation for father would be adequate. Paskowitz v. Paskowitz, reversing grant of relocation despite claim of economic necessity because both parents were sharing time with children evenly. Alexander versus Alexander, affirming the order denying mother's petition to relocate from Broward to Tallahassee, where move was possibly going to improve mother's quality of life, but not the children's, and was not in the children's best interest. Muller versus Muller, reversing grant of petition by mother to relocate based on insubstantial evidence regarding economic improvement and adequate visitation with father. Echegerada versus Echegerada, affirming denial of relocation petition by wife and awarding custody to father. Segarra versus Segarra, barring relocation because it, quote, would result in a significant diminishment of the excellent relationship between the father and the child, and thus would not be in the best interest of the child. In addition to the 13 cases denying relocation above, Vivian, Rossman, Fredman, Coyle, Paskowitz, Alexander, Escazarada, Muller, Schaefer, Mata, Sisemsky, Kuntz, Eckert. The cases providing opinions where relocation has been upheld or deemed permissible have involved very different fact patterns involving unequal parenting capacities and histories, egregious behavior by one spouse, and or presence of dire economic necessities. For example, Valkey, Supra, Miller versus Miller, the presence of economic necessity and unequal parenting situation and capacity. Orta versus Suarez, allowing relocation because of economic necessity for wife, egregious behavior by husband, and history of wife serving as primary caregiver. Norris v. Heckerman, evidence of unequal parenting involvement. In sum, the cases offered above clearly provide articulate principles of decisions that directly cover the facts in this case. Those principles can be reduced succinctly. The courts will not allow relocation in instances where there is no economic necessity and both parents are able and loving caregivers. In this case, no one has a job that has moved or a spouse who has a job which has been moved, and no one enjoys status as primary residential parent. On the contrary, both parties are fully employed in excellent positions. Each parent is evenly involved in a rotating time-sharing arrangement, and the children are flourishing. The present case creates easy facts that, under the law, cry out for swift and certain resolution in a husband's favor. E. The wife's pleadings fail to state a cause of action upon which relief can be granted. The wife's amended petition does not allege facts that would be required for a petition to relocate to be granted. On the issue of economic necessity, the wife's motion to relocate fails to allege any facts supporting the claims that she needs to move based on economic considerations. First, she does not and cannot plausibly allege that she is having economic trouble on her six-figure salary as a law professor. Second, nowhere in her pleading does she allege that she even looked for higher paying jobs in Tallahassee and couldn't find such higher paying work. All she alleges is that there is a job as a private firm attorney in South Florida for her that perhaps would offer, once cost of living is factored in, a bit more money, but with no comparable benefits, flexibility, and stability to her present sinecure, in which she indisputably has lots of time to spend with the children. And since the children are at no risk of experiencing financial difficulties or deprivations in their current environment with the parents in their current positions, there's no reason to think that the best interests of the children would require the wife to move. Indeed, the family's joint economic pie would suffer substantially if the relocation were to be authorized, simply because, in order to maintain his job and have a meaningful connection to his children, husband would have to incur the cost of 2 homes, 2 cars, and expensive weekly flights and airport parking. By contrast, the status quo is a recipe for financial success that would benefit the children in terms of their opportunities, educational and otherwise. On the issue involving parenting fitness and equality of caregiving responsibility, the wife's pleading nowhere alleges that husband is unfit or unloving as a parent, or that the children are not close to the husband. Moreover, there is no disputing the fact that the parents have been engaged in equal time sharing since the separation. As long as there is no factual dispute over the capacity and desire of both parents to play active roles, then this too indicates the failing of wife's petition to relocate as a matter of law. Wife's pleading fails to allege facts that would be enough to state a cause of action upon which relief can be granted. Even if all facts alleged in wife's pleadings are construed in her favor, there is no rational basis to award relocation. See Meadows Community Association Inc. versus Russell Tuddy, noting that allegations of fact must be construed in non-moving parties' favor when assessing motions to dismiss for failure to state a cause of action. It is painfully obvious that in seeking a unilateral relocation, the wife is wasting the court's time and the family's hard earned assets. The court should dismiss the relocation petition with prejudice and award litigation costs to husband for having to endure frivolous litigation. Signed, Daniel Markel. Wife's memorandum of facts and law in support of her petition to relocate to Coral Springs, Florida with the minor children. The wife, Wendi Adelson, files this memorandum of facts and law in support of her petition to relocate with the minor children and would state A, facts of the case. The parties were married in 2006 in Boca Raton, Florida. The petition for dissolution of marriage was filed in 2012, making this a 6-year marriage. During the course of this short-term marriage, the parties have resided in Miami, Washington, D.C., and Tallahassee. The wife is from Coral Springs, and her entire immediate family resides in the South Florida area. The husband is from Canada, and his family remains in Canada. The husband is not a United States citizen. Neither party has family in Tallahassee. Both parties are currently law professors at Florida State University. The husband is a tenured professor, while the wife is a clinical, non-tenure track professor. The parties have 2 small children, ages 2 and 3. Although the wife acknowledges the great love that both parties have for the children, she submits that she has been the primary parent of the boys up until the date of filing the petition for dissolution of marriage. The husband has traveled a great deal during the course of the marriage, attending conferences and giving lectures. Although the husband did take off sometime after the birth of the children, he traveled to Israel and New York as well as other conferences during this time and also published legal articles. Much of the parenting prior to the petition was the primary responsibility of the wife. The husband has consistently expressed to the wife that he desires to move to a larger metropolitan area, which has a larger Jewish community than Tallahassee. During the course of the parties' marriage, he has continued to attempt to attain a professorship elsewhere. The parties have expressed a desire to relocate to the South Florida area throughout the marriage. The husband has indicated that he most definitely would like to move before the boys reach bar mitzvah age, which is around 13 years old. The wife has been very unhappy in the marriage and filed her petition for dissolution of marriage in August 2012. The husband continues to characterize this as an abandonment of the family. At no time has the wife abandoned the children. She is divorcing the husband due to her unhappiness with him in the marriage, and she only moved out of the home because she knew that the husband would not. The husband's statements of abandonment are unfounded and not supported by fact or law. He simply is having difficulty accepting her decision. In fact, he is having so much difficulty that he has told several of his colleagues and friends that she must have mental health issues. He also told them that she has stolen money from him when she took her one half of the joint bank account. The husband's position at the law school is a considerably different one than the wife's. He earns almost $180,000 per year as a full-time tenured professor. Until 2 months ago, the wife was a, quote, visiting professor with a non-permanent position. The husband has often told the wife that her position at the law school was only due to him. Since the filing of the petition and the separation of the parties, the wife has been offered a position at a private law firm in South Florida, offering more money and considerably more opportunity for advancement than her current tenuous position. The wife would like to relocate with the minor children because this position is very advantageous. Her family is in South Florida. It was always the intent of the parties to try to move back to South Florida. The husband has made it difficult for the wife with her colleagues at her current position due to his statements and actions. And the husband's intent is to relocate to a larger area at some point, so the wife is merely stuck in Tallahassee until the husband decides that the time is right for him to leave. The husband has family from Canada that spends time every year in South Florida and has a flexible job so he can travel to South Florida regularly to see the children. The children are very close to the wife's extended family, and this move is in their best interest. B. Law in this case. The relocation statute in its present form is relatively new and not much case law interpreting it has been decided at this point. It appears from the little case law that has been promulgated that each decision is fact specific. Contrary to the husband's assertions in his memorandum of law, several recent cases have either affirmed a relocation or reversed a denial of relocation. Also, it is important to note a distinction in the status of the cases that the husband glosses over. This is an initial dissolution of marriage in which no parenting plan has been established. This is not a change from any established visitation or parenting schedule. It is the establishment of a parenting schedule, including a consideration for relocation. The husband submits that no recent cases have allowed relocation when the parties have an equal time-sharing arrangement. First of all, no arrangement exists currently. The wife is requesting that this court establish a time-sharing arrangement both if she is allowed to relocate with the minor children and if she is not allowed to do so. She does not believe that a 50-50 time-sharing arrangement is in the children's best interest. The husband travels a great deal and has not been the primary caretaker of the children. The parties have been unable, during the pendency of this proceeding, to agree on a set time sharing of the children. Due to the husband's intransigence in this regard, the wife has acquiesced more or less to his demands for time sharing. The wife does not believe that this has been in the best interest of the children, and it is merely to placate the husband. He is so determined to have a 50-50 time sharing that he insists that the days change every week to work with his travel schedule. And if the wife requests even an hour more, he insists that this hour be made up somewhere. His schedule has not allowed for a consistent and set schedule for the children. This is not in their best interest and is merely in the interest of the husband. The case law indicates that the entire childhood of parenting of the children be reviewed in making determinations as to the parenting plan. Pre-litigation division of labor should be reviewed and not just who most conveniently controls the parenting. Young v. Hector. It is not appropriate to only review the last 4 to 5 months of parenting when looking at the best interests of the children. Before the filing of the petition, the child care was not a 50-50 time sharing by any stretch of the imagination. The court must review the factors in Florida Statute 61.13001 in making its determination as to relocation, both temporary and permanent. Those factors and the facts in this case as to how they impact the children are as below. 1. The nature, quality, extent of involvement, and duration of the children's relationship with the parent or other person proposing to relocate with the child and with the non-relocating parent, other persons, siblings, half-siblings, and other significant persons in the child's life. The wife has extended family and friends in the South Florida area, and the husband has no family in the Tallahassee area. The minor children have no other siblings. The children are close to both parents. 2. The age and developmental stage of the child, the needs of the child, and the likely impact the relocation will have on the child's physical, educational, and emotional development, taking into consideration any special needs of the child. The relocation will not impact the children too greatly as they are not yet school age. They will be allowed to emotionally develop well and will have more support from extended family relationships. 3. The feasibility of preserving the relationship between the non-relocating parent or other person and the child through substitute arrangements that take into consideration the logistics of contact, access, and time sharing, as well as the financial circumstances of the parties, whether those factors are sufficient to foster a continuing, meaningful relationship between the child and the non-relocating parent or other person, and the likelihood of compliance with the substitute arrangements by the relocating parent or other person once he or she is out of the jurisdiction of the court. The wife will comply with all substitute arrangements, and the parenting time for the husband should be as extensive as his employment will allow. 4. The child's preference, taking into consideration the age and maturity of the child. The children are too young to voice any preference. 5. Whether the relocation will enhance the general quality of life for both the parent or other person seeking the relocation and the child, including but not limited to financial or emotional benefits or educational opportunities. The quality of life for both the wife and the children will improve greatly as the wife will have a better, more consistent job, the help of extended family, and the children will have extended family as well. 6. The reasons each parent or other person is seeking or opposing the relocation. The wife is seeking to relocate for a better, more stable job and to have the children grow up in a stable and consistent environment and not relocate all across the country as the husband moves for ever better positions. 7. The current employment and economic circumstances of each parent or other person, and whether the proposed relocation is necessary to improve the economic circumstances of the parent or other person seeking relocation of the child. The wife's employment is going to be considerably better with this move. The husband has no intention of staying in Tallahassee and plan eventually to move to a much larger city and more prestigious school. The husband has considered Miami, New York, Washington, D.C., Houston, and St. Louis among his choices. 8. That the relocation is sought in good faith and the extent to which the objecting parent has fulfilled his or her financial obligations to the parent or other person seeking relocation, including child support, spousal support, and marital property and marital debt obligations. The wife is seeking this relocation in good faith. 9. The career and other opportunities available to the objecting parent or other person if the relocation occurs. The career opportunities for the husband are the same regardless of the wife's relocation and will probably create a situation where the transportation is even better for the husband when he moves to a larger metropolitan area. 10. A history of substance abuse or domestic violence as defined in Section 741.28 or which meets the criteria of Section 39.8061D by either parent, including a consideration of the severity of such conduct and the failure or success of any attempts at rehabilitation. This is not applicable. A review of some cases regarding relocation, and not the ones submitted by the husband, indicates that the judicial decision to allow relocation will be upheld unless it is an abuse of discretion, Norris v. Heckerman. When reviewing the cases and the law in this regard, it is important to note that there is no presumption for or against relocation when it will impact a parenting schedule. In this case, there is no parenting schedule, and the wife submits that a perfectly adequate one can be maintained, allowing the husband to fully parent and participate in the children's lives while allowing them to be part of a bigger Jewish community, their larger extended family, a better financial situation for the wife, and a more secure and friendly work environment for the wife. All of these factors point to the relocation being in the best interest of the children. The burden is on the wife to show that it is in their best interest, and once she has done so, then the burden turns to the husband to prove otherwise. The husband indicates that it is not in the wife's best interest, but the children's that is at stake. This is true. However, the review of the case law shows that facts very similar to those in this case have been held to be in the children's best interest. See Miller versus Miller, which reverses a denial of relocation, stating as the child was only 3 years old, he had little in way of meaningful school, community, or friendship ties. The mother had been the primary caretaker since birth, and the mother has a significantly better job offer in Atlanta, Georgia, than she had in Key West, Florida. Similarly, Orta versus Suarez overturned a denial of a relocation request from Coral Gables to California, indicating that the mother had met her burden of proof based upon the following facts. She could obtain significantly better employment in California. She had been the primary caretaker of the minor child. The husband's work schedule was more flexible, allowing him the ability to travel more for visitation than the wife. The reliance on the husband's promises to move to California had put the wife in an untenable situation, and the child was only 2 and would not be uprooted from any community. These facts are virtually identical to those in the case at bar, except that the wife, in this case, also has immediate family in South Florida. She is not asking to move nearly as far, and the husband actually intends to move at some point anyway. Finally, Wright v. Wright affirms a relocation request during the initial dissolution of marriage from Florida to the United Kingdom. The child in that case was 6 years old, and the wife actually moved during the pendency of the divorce without the court's or husband's permission. Nevertheless, the appellate court upheld the relocation because the child would be close to extended family in England. The wife had a better job in England. She was from the United Kingdom, and she now had a significant other. These facts are not as persuasive as those in the case at bar. When considering the factor of the statute along with the case law and the facts in this case, it is evident that a move to South Florida with the minor children is in the best interest of the children, and adequate secondary parenting can be provided by the husband so that he is able to maintain a meaningful relationship with the children. Wherefore, the wife, Wendi Adelson, respectfully requests that this court allow her to request to relocate to Coral Springs with the minor children and establish a parenting schedule allowing each parent appropriate time sharing and the sharing of the expense and time involved with travel. Husband's reply to wife's memorandum of law in support of her petition to relocate to Coral Springs, Florida with the minor children. Comes now, the respondent husband, Daniel Markel, by and through his underassigned attorney, and files this reply in support of his motion to dismiss and in response to the wife's memorandum of law in support of her petition to relocate to Coral Springs, Florida with the minor children. This reply is to focus and distill the legal framework that governs the relocation petition filed by the wife. A. The standards for motion to dismiss in Florida. Under the Florida Family Law Rules of Procedure, the Florida Rules of Civil Procedure apply to this motion. See Family Law Rule 12.110. Under the General Rules of Pleading, it's Florida Rule of Civil Procedure 1.110, a litigant in Florida must engage in fact pleading, not notice pleading. Quote, unlike the pleading requirements in the federal courts where notice pleading is the prevailing standard, the Florida Rules of Civil Procedure require fact pleading. Close quote, Ranger Construction versus Martin Companies. What this means is that in order to state a cause of action, a petition must allege sufficient ultimate facts to show that the pleader is entitled to relief. At the outset of a suit, litigants must state their pleadings with sufficient particularity for a defense to be prepared. Whether a pleading is sufficient to state a cause of action is an issue of law. Wife's petition is facially defective for two reasons. First, even if all the facts in the petition were taken as true, it still fails to allege adequate facts to state a cause of action. That's because, as explained in husband's memorandum of law and motion to dismiss, the wife nowhere in the petition pleads that there is some economic necessity or that there is a parent who is or has been unwilling or unable to play a vital role in the raising of the minor children. Second, under the fact pleading standards of this state, wife's petition fails to state her case, quote, with sufficient particularity for defense to be prepared, close quote. We take these points up in turn. B. Relocation is only allowed under specific and stringent criteria, which are neither present nor alleged by wife. Since husband has filed a motion to dismiss a petition to relocate based on his memorandum of law, the key issues are what's been pled and what the legal framework is. In reviewing a motion to dismiss, the facts that are pled must be construed in the petitioner's favor. Even under that forgiving standard, however, wife's pleading is manifestly insufficient in light of the legal framework governing the operative relocation statute. That statute, Florida Statute 61.13001, has been made clear in the 46 cases that have cited or interpreted that statute since it was enacted. Footnote 1. Contrary to wife's memorandum at 3, around 18 cases or so actually provide relevant guidance for this court, and husband's memorandum of law addressed the vast majority of them. While each decision is specific to the situation, there is an obvious pattern that characterizes the outcomes, and that was the point of husband's memorandum of law, to show that there is a definite contour as to what counts as an abuse of discretion by trial judges on matters of relocation. Interpreting that statute, the Florida courts followed an abundantly clear pattern that was identified in the husband's memorandum of law. Specifically, relocation in this state has never been authorized under this governing statute where there has been no economic necessity and where both loving parents and where both parents are and have been substantially involved and are equally capable and loving. Put differently, any time a court has permitted relocation and it has been allowed on a very small number of cases, that decision has only been upheld because of some showing of either economic necessity created through no fault of the relocating parent or because some showing of a manifestly unequal relationship between the parents vis-a-vis the children or both. Husband's memorandum of law identified 13 cases where relocation were either denied, and then those denials were upheld on appeal, or granted and then reversed as an abuse of discretion because the facts didn't satisfy the criteria just discussed. Contrary to wife's memorandum at 3, which states that husband's memorandum omitted any discussion of cases where relocation had been permitted, husband's memorandum of law also identified the very few, 4, cases in which relocation had been permitted and upheld, or denied and then reversed and remanded for reconsideration. Footnote 2. Husband's memorandum did accidentally omit discussion of right, which is discussed and distinguished infra. By contrast, wife's initial petition did not cite a single case in support of its petition. Now, in desperation, and only a few days before the hearing, wife's memorandum of law musters citation to fewer than a handful of cases, all but one of which were addressed in husband's earlier briefing. Specifically, wife, at page 6 and 7 of her memorandum, cites and discusses the following 4 cases: Norris, Miller, Orta, and Wright versus Wright. To elaborate briefly, Norris versus Heckerman provides no support for wife's case as the relocation was permitted there in a context where the husband had been away from the children, living in a different state, and only later on moved to where the children were and began, quote, exercising weekly visitation. By contrast, Mr. Markel, the husband here, has been intimately involved with every facet of the children's lives from day one and continues to be a daily presence in their lives. Mrs. Adelson, the wife here, stipulates that husband has great love for the children, that the children are very close to both parents, and that the parents have been time sharing on an equal basis from the beginning of the separation more than 9 months ago. She also, as developed below in section C, offers no specific allegations about how she was in fact the primary parent prior to the separation. It's a bland assertion that fails the standard of fact pleading. Miller versus Miller, likewise, is of no support for wife. In Miller, the mother had no economic prospects in her city, whereas she was offered a job in the new city and she was getting remarried. Moreover, and importantly, the husband in Miller was working 2 jobs and was deemed to be either unable or unwilling to attend to the child adequately. Furthermore, the mother was primary caregiver for 5 nights a week and was home with the child since birth. Finally, the court didn't even reverse and order the relocation. Rather, it just remanded the case for further consideration. By contrast, Ms. Adelson does not deny that she is employed as clinical professor of law at Florida State. Although she was in a visiting position prior to the fall of 2012, in December 2012, she was promoted to be the director of a legal clinic that the law school faculty unanimously approved, and she was hired after a national search was performed. Moreover, except for 3 months of maternity leave that she took after the birth of each child, she has worked full-time at the university. She has a stable 6-figure job waiting for her at FSU. Accordingly, there is no economic necessity. Moreover, husband is not working 2 jobs, but just one, as a full tenured professor. He also has plenty of time and inclination to spend with the children here in Tallahassee, and there is no dispute that he is an involved and loving father who was keen to be a daily presence in the lives of his children. Third, Orta versus Suarez, again, is mischaracterized by wife. The wife in that case was a foreign national and foreign trade dentist who could not be certified anywhere in the United States besides California. Furthermore, her husband had been dishonest with her in numerous ways that left the wife and child destitute and had made promises to her that she had relied upon to her detriment. But the key point is that the wife in that case had an economic necessity created through no fault of her own. By contrast, Ms. Adelson's stated hope is to make scarcely a few dollars more in her new position compared to what she is able to earn here in Tallahassee in a position that is stable and yet flexible. Moreover, unlike the husband in the Orta case, There is no allegation that Mr. Markel has sought to deny Ms. Adelson any appropriate child support. Finally, wife refers to right versus right. The key fact omitted from wife's discussion is that Ms. Wright had no visa to work in the United States, and so relocation to her home country was an economic necessity. As with Miller versus Miller and in Orta, right doesn't involve merely a better job for the wife. Rather, no plausible work opportunities were available for these wives where they were. Again, and by contrast, Ms. Adelson is employed as a legal educator in what is, by any measure, a wonderful job with a public university during a period of great economic uncertainty for those in private practice. And as such, it is one with job security, a panoply of benefits, and fantastic flexibility that, according to her own admission, redounds to the benefit of the children. Needless to say, this is a position that she deserves on her own merits and is earned on her own merits by dint of her hard work for the university and the College of Law over the years. To summarize this point, wife's memorandum of law not only fails to address the 13 cases that all denied relocation, but wife's petition relies on the cases that husband already discussed and distinguished. Wife's petition is facially defective under Florida law because it fails to allege any basis for economic necessity. Wife doesn't claim that she can't make ends meet in a low-cost city on six figures, nor does she claim that she couldn't find higher-paying work in Tallahassee in a private law firm. She doesn't allege any necessity, especially one that is created through no fault of her own. Second, wife never alleges the existence of a father who is or has been unable or unwilling to be deeply and lovingly involved in the lives of the children. Wife's memorandum concedes that husband has great love for the children, that children are close to him, and that he has been vigilant about protecting his parental rights so that he can be as involved in the children's lives as possible. In short, there is no legal basis for this petition to continue. It should be dismissed with prejudice and costs awarded. C. There's inadequate specificity to prepare a defense. Wife's petition is defective because it fails to satisfy the standards necessary for fact pleading in Florida courts. It makes grand and sweeping claims without offering specificity adequate to prepare a defense. Here are just a few examples. On page 2 of her memorandum, wife, quote, submits that she has been the primary parent of the boys up until the date of filing the petition for dissolution, close quote. She bolsters this putatively by reference to the fact that husband has traveled for work, but she doesn't identify how much he has traveled for work, how much she has traveled for work or for fun, and that has been extensive, as will be shown at the hearing, or what standards she thinks are relevant to determining who is a primary parent. 2. On page 2, wife writes that husband is, quote, having so much difficulty, close quote, with wife's decision to leave the marriage that he, quote, told several of her colleagues and friends that she must have mental health issues, close quote, and that, quote, she has stolen money from him. She doesn't identify who these people are or when these allegations were made or whether she denies these allegations. 3. On page 3, she describes her position as tenuous and that husband has made it difficult for the wife and her colleagues due to his statements and actions. But she does not identify any way in which her position is tenuous, other than the fact that she is not a tenured professor. One could be in a stable, flexible, and wonderful position without enjoying academic tenure. The other persons who have the same position as her have been there since 1991, 1995, 1995, and 2001. There doesn't seem to be anything tenuous about being a clinical professor at a public university. Moreover, wife does not identify a single instance in terms of where or how things were difficult for her in her employment. No adequate defense can be prepared against such vague and unsupported assertions. She has been working continuously in her position. She is slated to teach this fall at the College of Law, and since she works in a separate building, she has only seen the husband at the workplace on 2 or 3 occasions since October. In short, wife asserts that husband has made it difficult for the wife at work with her colleagues, but offers no allegations of specific instances of ways in which it is difficult. Footnote 3. Moreover, the evidence will show that, in fact, the College of Law has publicly showered accolades and publicity upon Ms. Adelson, both before and subsequent to her promotion to clinical professor. In short, she has a contract with a public university which can only fire for just cause under the relevant collective bargaining agreements. By contrast, there is no evidence of even a contract with the private law firm, just a two-line email confirmation of an offer of employment as an at-will employee, with no mention of benefits, flexibility, or stability. Moreover, any claims of difficulty in the workplace are utterly belied by the fact that after the separation, the faculty unanimously decided to make wife's legal clinic permanent, and her being hired to direct the clinic was the unanimous decision of the ad hoc committee that conducted a national search. In short, wife asserts that her position at FSU is tenuous but doesn't explain why an at will employee relationship with a private law firm would be less tenuous than a state employee position with a university in a collective bargaining agreement. 4. On page 4, wife writes that no arrangement exists currently regarding parenting. She does not even allege that she has ever offered a set time sharing arrangement to which husband has refused. Wife doesn't allege any specific instance or evidence of intransigence other than that husband wants a 50-50 arrangement. She doesn't allege any specific instance in which husband wouldn't offer extra hours. Moreover, she doesn't offer any allegation of her own willingness to offer extra hours without makeup time. Footnote 4. As the evidence will show, husband has frequently sought to facilitate long-term planning, and wife has been the one to accept parenting agreements and then repudiate the fact of her agreement and instead desire to renegotiate and extract more time with the children. The evidence will also show that wife has been out of town more than the husband for work and for pleasure travel, a choice that the husband has been happy to accommodate. As husband has told wife in person and in numerous emails, he will always be happy to work around her reasonable preferences. 5. On page 5, wife asserts that she will have a, quote, better, more consistent job. But she doesn't explain what's better or what makes it more consistent or more stable than being a clinical professor in a clinic that has been made a permanent part of the College of Law, nor does she explain how working as a law firm associate is preferable from the standpoint of the children regarding how much time she will get to spend with them. 6. The wife states on page 5-6 that husband, quote, has no intention of staying in Tallahassee, but she doesn't say when he said that, to whom, and with what qualifications, if any. She references jobs or cities he has considered, but she does not mention that all of those were prior to having children, let alone prior to the separation. D. Various errors pervade wife's memorandum. Although pleadings are to be read with charity, there is a need for specificity and plausibility under the Florida civil pleading standards. The wife's pleading reveals a parade of obviously false statements of fact that cumulatively this demonstrate that the petition warrants little deference. 1. Contrary to the wife's memorandum at 1, the couple never lived as a married couple in Washington, D.C. They lived there for less than 3 months while they were engaged in the summer of 2005 before they moved to Tallahassee, where they have lived since 2005, except for the academic year of 2006 to 2007. 2. Wife's, quote, entire immediate family, close quote, does not live in the South Florida area, contrary to her memorandum at 1. Her parents and an older brother, who is an unmarried and hard-working periodontist without children, live there. Her oldest brother, who is married and has 2 children, lives in upstate New York. She has no first cousins or uncles or aunts in South Florida. 3. While neither party has extended family in Tallahassee, the parties have lived in Tallahassee for all but 1 year since 2005, and more importantly, the children have lived here their entire lives. Ben is turning 4 next month, and Lincoln is almost 3. The parties and the children have over 50 families with whom they have celebrated milestones or done play dates with, and they are doing fine in their current environment, even after the separation. 4. Wife writes that she filed her petition in August 2012. This is false. It was on September 10th, 2012, the date that she told husband for the first time that she wanted a divorce, and the date that he came home to a house with no wife and no children. The whole separation and filing for divorce was a complete surprise to husband and to his friends, family, and colleagues. 5. Wife writes that wife was a visiting professor, quote, until 2 months ago. But in fact, the dean of the College of Law announced Wendy's appointment to a permanent position in December 2012. That was 6 months ago. E. Conclusion. In sum, while pleadings must normally be read with charity to the petitioner, it does not mean suspension of all disbelief, especially in a fact pleading jurisdiction like Florida. Pleadings must be specific and offer some form of plausibility. The wife's pleadings are vague, filled with rank and obvious falsehoods, and the legal analysis is fundamentally inept. Even if all the facts in the wife's petition were taken as true, there is no allegation of economic necessity or parents who are unwilling or unable to be involved in a deep and loving fashion. For the preceding reasons, the petition should be dismissed with prejudice and costs awarded to the husband. Indeed, if costs are not awarded, then wife and her affluent parents, who are bankrolling wife's litigation so that they can enjoy closer access to the grandchildren, will persist in vexatious and groundless litigation and thereby prevent the parents from reaching a space where they can cooperate, collaborate, and communicate effectively and warmly in the project of raising their wonderful children. Order on wife's petition to relocate with the minor children. This cause having come before the court on the petition of the wife to relocate with the minor children to South Florida, and the court having heard argument of counsel and testimony presented by the wife, and the wife having rested her case, does order and adjudge as follows. 1. This court does not find that wife has met her burden of proof that a relocation is in the best interest of the minor children. 2. As such, the parties stipulate to the denial with prejudice of the wife's petition for request to relocate with the minor children. 3. The court orders the parties to meet mediation to resolve the remaining issues pending final hearing in this case, currently set for July 31st and August 1st, 2013. 4. The parties have agreed to the following temporary parenting schedule without precedential value for the time up to the final hearing. A. The month of June 2013 has been resolved. B. The husband shall have from the end of June until July 4th at 9:30 a.m. C. The wife shall have July 4th at 9:30 a.m. until July 15th at 9:30 a.m. D. The husband shall have July 15th at 9:30 a.m. until July 22nd at 9:30 a.m. E. The wife shall have July 22nd at 9:30 a.m. until July 29th at 9:30 a.m. F. The husband shall have July 29th a.m. until August 2nd at 9:30 a.m. G. The wife shall have August 2nd at 9:30 a.m. until either the evening of August 6th or the morning of August 7th, depending on the flight schedule for the husband as per below. H. The husband shall be allowed to take the children to Canada from August 7th until August 21st, 2013, and the wife shall sign all necessary paperwork to do so. I. The parties agree to make a good faith effort for a daily phone call for the children and the parent out of residency, and the parent in residency shall facilitate that call. J. The parties shall make a good faith effort for Skype every 4 days between 6 and 8 p.m. for the parent out of residency, and the parent with the minor children shall place the Skype. Done and ordered in chambers in Tallahassee, Leon County, Florida, on this 20th day of June 2013. Signed, Judge Barbara K. Hobbs.